May it please the court, counsels. My name is David Green, Your Honors, and I represent the appellant, the Hayslips. Your Honors, we are here today on an appeal of an order referring the parties to arbitration. This is an order from a magistrate judge.
Did you want 5 minutes for rebuttal or some other?
If I could, Your Honor, I apologize for not requesting that. Thank you. So, Your Honors, we're here on a order referring the parties to arbitration. The reason that the magistrate judge referred the parties to arbitration is that this is a dispute over the construction of the exterior stucco system of a single-family home. The home was built by U.S. Home Corporation back in 2007. The home was originally conveyed by U.S. Home Corp to the Kennisons.
Is that relevant to whether or not the arbitration provision applies? Let's assume there's a valid dispute on construction. Tell me how that affects the arbitration applicability and the deed restrictions.
Yes, Your Honor. Where we're coming into an issue here is whether or not the arbitration provision in the deed is a valid or restrictive covenant.
That runs with the land or is personal.
Correct, Your Honor.
Are those issues covered in the notice of supplemental authority? They have filed a couple of cases, one written by Judge Morris. Tell me how those cases are distinguished from your contention. You can start with the HF Bay Fund LLC if you'd like.
Would you agree with the statement that the supplemental authority predominantly goes to the issue of arbitration and the desirability of arbitration and the public policy in favor of arbitration and the like? Is that what the supplemental cases are about?
Yes, Your Honor. I mean, I do agree that there is a presumption that arbitration is a favored form, a favored way of mediating or of resolving disputes.
But we have no Florida case on this specific issue of whether or not this arbitration provision runs with the land and is binding on subsequent purchasers. That's where we are, right?
Right. The narrow issue is whether or not that deed restriction is binding on a subsequent purchaser. When there was an issue, I guess, is the intent of the formation, and as to whether or not it's properly characterized as running with the land.
There have been a number of out-of-state cases that have been cited against your position, saying, hey, it should run with the land. We favor arbitration. Public policy is in favor of it. There's no reason for it not to, et cetera, et cetera. It seems like there's not a whole lot of case law, but what little case law there is against you.
Well, Your Honors,
I'd like to know what cases you would point me to say, no, look at these cases, these help me.
Yes, Your Honor. I believe that Sunderland was the first case. That's 656 Southern 2nd, 1356. That was the third DCA case at 1995. In that case, the Sunderland court held that and an agreement to assign rents and profits didn't create an interest in the property such that it was a covenant running with the land. So we have the cases, as I can best distill them, appear to center around some sort of physical intrusion into the land, which would qualify something as running with the land. So valid restrictive covenants, things like how tall your hedges can be, whether or not you can have pets, whether or not you have to pay dues to a common master association for the benefit of all the tracts of land, those have been held to be running with the land. Personal covenants, we had a case where a deed provided proceeds from a condemnation proceeding to the grantor. That was held that was not a covenant running with the land. It was a personal covenant. Same with Sunderland, assigning rents and profits, not a personal covenant. We also have SDS, which is the case involving a lessee who was in physical possession of the property. That was a case where it was found that because he was physically in possession and had the obligation to pay rents, that he basically assumed an arbitration provision under that lease agreement. So it seems that the physical intrusion onto the land seems to be the differentiation between running with the land versus personal covenants. Going back to appellant's cases...
if you're a developer and you want to build in arbitration as a remedy for something you've done wrong with building a property, the only way to do that for a subsequent purchaser is to put it in the deed restrictions. Is that a fair assessment?
There are different mechanisms.
No, a subsequent buyer is not going to sign something going back to an original contractor saying, okay, we'll arbitrate. it's only that first buyer would be bound, but they would be bound by the contract. They wouldn't need a deed restriction to necessarily bind them. This started creeping into deed restrictions fairly recently in the history of jurisprudence. Is that, am I thinking about this correctly?
Yes, absolutely, Your Honor. And in typical lawyer fashion, we have belt and suspenders approaches to the arbitration. We have arbitration provisions typically built into the purchase and sale agreements. We have arbitration provisions typically built into the express limited warranties provided by builders to consumers. And now we're seeing the trend of having these arbitration provisions built into the deeds themselves.
So why shouldn't the builder have why wouldn't that be a good thing, assuming we sort of have a clean slate here in Florida and we could follow the cases from Oregon and California and I think Oklahoma and say, you know what, there's no reason why these builders shouldn't have this protection, and in other areas of the law we favor arbitration, and arbitration works well, and we want that here in the state of Florida. And we could follow those other cases and say, if you don't want to buy a home where you're going to be subject to arbitration, then you got to buy a different home. You don't buy a U.S. Homes home that clearly has this provision. Why should we not go that direction?
Well, I don't like to bring in the parade of horribles argument, but that would be the trend of all the national builders just saying, well, let's start transforming these deeds as to just conveyances of property to making these restrictive covenants, saying we're going to further our corporate interests by limiting potential claims homeowners have against us for faulty building
Well, I
practices.
mean, there would be a way around that, theoretically. If I'm a subsequent buyer, I negotiate with the seller, hey, go get me a waiver from the builder of that provision, but I'm not even sure it would work, but since it would be personal to the builder, perhaps you could get a waiver as a condition of the sale, and then no one would sell houses.
Effectively, yes.
I'm not going to say, yes, they'll do that.
Yes, Your Honor, and that's the restriction that we're worried about, the resaleability of a house. If these become issues, we have a lot of stucco claims here in Florida. Stucco is just one of those issues that always pops up. It seems that nobody can get it right on either side. But when they do pop up, we have provisions and remedial statutes like the Florida Building Code where we have a cause of action to go after the builders. But here, I believe that would probably be stretching the nature of an arbitration provision from a personal covenant to one running with the land, when the nexus between it and the body of law concerning covenants running with the land seems to kind of stretch at that point.
Is an arbitration provision a burden or a benefit to a subsequent purchaser?
Depends on who you ask, Your Honor. Our position is that it's a burden. U.S. Home Court's position is that it's a benefit. Neither side can actually agree, but in this case, the homeowners have felt that it would be a burden, that their rights would be more properly adjudicated in a court of law versus an arbitration proceeding.
It's touch or concern the land, and if it is if an arbitration provision to force arbitration of a construction defect of a house that's on the land, tell me about the distinction between that and what you're saying is the sine qua non of touch and concern, which is an invasion.
The body of case law that I reviewed and that we filed in the brief seems to be that even on appellants' cases they cite, the cases all involve some physical intrusion onto the land. So you have cases like the Baker case, the Conoco Pipeline case, where pipes are physically laid over somebody's land. There's an easement granted, giving them access to come in and clear land. They messed up. They took some things out they weren't supposed to, and that brings a rise. The issues that are more tangential, the issues of intangible personal property, things that are not physically on the land like crops, mineral rights, rights of way, the easements, it seems that the cases that I've reviewed don't support the proposition that the intangible rights are touching and concerning the land sufficiently in order to transform that arbitration provision to something running with the land. We also point to the American International Group versus Cornerstone case. That was a case where a corporation was not bound by its successors, or agreements where the successor corporations were not bound by the parent corporation's agreements. In addition, we have a couple of cases. Obviously, Mall Industries versus Sheffield was a seminal case that both parties agreed properly supported the touch and concern test. In addition, we had In re T2 Green, which is a U.S. bankruptcy court out of South Carolina in 2006. In that case, it held that the covenants and the arbitration provisions in that case were running with the land because the rights granted gave homeowners access to country club properties, basically. So the residents had the right to access the facilities, use facilities, and that sort of entry onto land created something running with the land. Here, we've got something where somebody's injured, tort, or there's property damage in the house. The only recourse that they have is through the arbitration proceedings that U.S. Home Court favors.
Are you a proponent of this court certifying a question of great public importance, regardless of how we come down on the issue, because there's a novel question involved?
Yes, Your Honors. We like and we seek clarity on this. It's going to help, I think, both sides in their litigation efforts. And these are something that are going to come up again and again. There's a lot of subsequent purchasers out there who are seeking not to be bound by arbitration provisions entered into their predecessors in interest. And it appears that the body of case law, you can draw both conclusions fairly reasonably, that it can either run with the land or it's a personal agreement.
You want to save the rest of your time for rebuttal?
I would, Your Honor. Thank you.
Okay, you got it.
May it please the court, Your Honors. David Gersten for appellee. With me is Larry Doherty, who is co-author of the brief, and his firm is also trial counsel below. May I proceed?
Yes, sir.
Thank you very much. Your Honors clearly have a handle on the very nature of this case, and it's very straightforward. It deals with something as mundane as deed restrictions that are common throughout not only the state of Florida, but the United States as well. And I would like to at least touch on one or two questions that came from the panel. And this is clearly not a referendum on arbitration. It's emblazoned in the law, both at a national and state level. And a question came out, is this a burden or a benefit? There is actually case law that addresses it directly from the United States Supreme Court. If you look at the ATT case versus Concepcion, came out within, I believe it was 2010, 2011. They talk about the benefits of the speedy resolution, and it's more cost effective. And it lets people know where they stand much quicker than going through the normal legal process. There are other cases that also stand for the same proposition. I believe Baker versus Conoco that Judge Black did refer to, the Oklahoma case, also talks about it. There's also a Supreme Court case out of the state of California, the Pinnacle case, which is cited in the brief, also talks about the speedy resolution and how it's more cost effective. So it benefits both the developer, and Pinnacle is an excellent case for Your Honors to review, along with Baker versus Conoco, because it goes through, both cases go through a fairly scholarly presentation about covenants running with the land, and specifically with, as Your Honor has mentioned, the California case, Oregon, and of course the more recent federal case, Baker versus Conoco. They take an analysis either on contract or on real estate grounds. But if Your Honor kind of likes digging at Your Honors, like kind of dig into the law a little bit deeper, there's a case that we did cite, Dunn versus Barton, that takes us briefly into the period in Florida right after the Civil War, which is in the 1870s. And it's an interesting case, Your Honor.
You supplemental authority, I noticed.
Well, it's Dunn versus Barton, but they refer to a bar, and I have to quote this, a house of improper character. And what it does state in that, going back to the 1870s, and in a nutshell, the covenant runs with the land if it affects the mode of enjoyment of the premises.
Well, this is before was it arbitration even invented back then?
Not that I know. Probably settlement was, but arbitration, no. I'm just saying it's just, Florida courts have addressed it probably on 3.5 out of 4, and the 3 foreign jurisdiction cases have addressed it on 4 out of 4, specifically does an arbitration provision in a recorded deed run with the land? And as this court has noted, and I did make a mistake in the brief, and I apologize, Hagan versus Sable Palms, I said it was the Supreme Court, it was this court, which was really on the forefront, a 1966 case, subsequently followed recently in the Rios case in 2015. But nonetheless, it goes into the analysis of the importance of real estate. We all realize, living in this great state, that real estate is perhaps not even perhaps, is the greatest economic engine for the state of Florida. Everybody wants to come down from up north and have their little piece of the sunshine, and get a home and know what it's like to live in Florida and be close to the water, be it a lake or the ocean. So these provisions going into a deed, actually, I believe if you look at the Pinnacle case, talk about how it benefits communities. And when you think about it, this case is probably about as mundane as you can get, because it's stucco, which I guess is mud, and that's pretty much what it's about. And with a mundane case like this, you could get it rapidly determined by an arbitrator.
Well, you're saying, is that a benefit to the homeowner or to the builder?
It's to both. And
How do you quantify that assessment that it's a benefit to the homeowner? Because why are we here? If they thought it was a benefit and there's data supporting that argument, why is it not being cited by either side?
I'm sorry.
I get the impression that the homeowner does not want arbitration, and that's why we're here.
This
They don't
homeowner.
want arbitration because they think it'll give them a less favorable result than a jury trial or a judge trial.
Fair. Now I understand the
So
question.
I'm trying to find out, is there any way to quantify that belief?
Well, yes.
You're saying it doesn't matter, they're going to be treated very fairly, we want to arbitrate this.
Well, the answer is yes. Within the deed itself, there is a provision as to who pays for the filing fee, which is $750, and after that, the developer, pursuant to this deed, is required to pay the next $2,000. If this is, and by the way, it also provides for mediation that the developer would be paying for as well, and I think everybody would agree, including any homeowner, mediation is good. So it's a two-part process. Let's mediate. Is there liability? How much do you want? If you settle it, it's gone in very short order. If you go the next step to arbitration, it's quantified within the deed that the developer pays the first $2,000. And, I'm sorry, Your Honor.
No, when you mention the economic aspect, that's part two of this movie, right? That hasn't been argued in this appeal, but that could be another argument down the road. At what point do you start having economics be a factor in saying it's a contract of adhesion or something along those lines?
Sort of like a Judge Posner, economics applying to all aspects of law.
Sort of like that.
It's sort of like that. It's probably, because it's not part of this appeal to go down the economic road, I only brought out what was in the deed specifically.
I'm with you, and I appreciate that.
But that being said, we do know that at least the Supreme Court of California and the U.S. Supreme Court have talked about the benefit of the speedy arbitration that we have.
If we were to follow the cases of other jurisdictions that said this ran with the land, and I don't want to mischaracterize your argument, it touches the land because the construction defect dispute that's subject to arbitration is based on a structure that's on the land.
Correct.
What are some examples of provisions in deeds and deed restrictions that don't run with the land? Give me some examples of what would be left over as something that doesn't touch or run with the land. If we adopt this, what I'm sure the appellant would say, attenuated touching theory.
A very crystal clear would be a deed restriction based on race or a deed restriction based on religion. That certainly would be improper.
Those would be unenforceable for different reasons. I'm saying,
Correct.
what would not meet the test of touch and concern or touch the land if we adopted, and I'm not saying I agree either way, I'm just saying what I believe the appellant would say was an attenuated theory regarding the touching of the land, meaning some intangible right of the immediate purchaser to, or the seller to arbitration being something that touches or concerns the land. If we adopt that, what's left what type of deed restriction would be left that doesn't touch or concern the land?
Well, I'm off the cuff here, Your Honor, I'm thinking maybe about taking your RV and putting it up on cinder blocks and customizing it out in front of a beautiful community like Davis Island or Harbor Island or something like that.
So that doesn't run with the land?
It doesn't necessarily touch the land, Your Honor. This is off, I haven't anticipated that question, Your Honor. But I think what we can do under any circumstances is let's look at the deed restriction that's in this deed, the covenant that's in this deed, and specifically would tell us what the intent of the parties is and what is covered, specifically what is covered. And if we look at the Seifert case, Seifert, which was decided in 1999 by, oddly enough, a completely different Florida Supreme Court, said, well, the intent has to be manifest by what's in the document. And we know the intent in this document because it binds heirs, successors, assigns, and occupants, and the deed specifically states it runs with the land. So we have that clearly as to what the manifested intent is in the deed. And Your Honor, the only way probably to address it is if a situation comes up and it happens and it's not in the deed, sorry, no arbitration. Any other questions, Your Honor? Well, I do want to note one thing that was stated. The mall industries was one of the tests, but actually if you look at the order from below, it also talks about the Winn-Dixie versus Dolgen Corp test. Just to be clear, this provision comports with either mall industries versus Sheffield out of the third or Winn-Dixie versus Dolgen Corp out of the fourth. Two separate tests, both of them were mentioned in the order. So I ask that the court, in closing, Your Honor, please look at the Dun & Barton case just because it's a fun read. The Silver Springs case from 1903, also for the same proposition that when you accept a deed and you enter into possession, you're deemed that such acts expressly agreed to do what is stipulated in the deed, even though he did not sign the deed. And with that, Your Honor, if you have no further questions, I'll sit down.
All right, thanks very much.
Thank you very much, Your Honor.
And you have 5 minutes for rebuttal. I won't start the clock until you get to the podium. Last time I said that, the attorney said, well, I'll start talking from the chair.
I'll use a lectern if that's all right. Your Honors, to address briefly some of Appellee's arguments, the first case I'd probably turn the court's attention to would be the Two Islands case at 239 Southern 3rd 115. This was a 3rd DCA case just from last year. The court there gave a little bit more insight onto what constitutes something a covenant running with the land. In that case, the court found that the covenant must create an interest in the property itself and affect the mode and use or enjoyment of the property. So in that case, what is the interest that U.S. Home Corp has in the Hayslips home? They don't have any ownership interest. They don't have a right to re-enter the land. They don't have any easements. They have no right to be on that property physically or affect the use or enjoyment of that property other than if there is a dispute. You have to go ahead and submit to the Florida Building Code's alternative dispute resolution procedures, which we did in this case. Failing that, you have to take your claims to arbitration. What claims you might be able to take to arbitration is not an issue before the court today, but in that case, the 3rd DCA did find that there has to be an interest in the property and affect the mode or use or enjoyment of the property. I don't see how an arbitration provision affects the mode or use, and that was still the issue with the Dunn versus Barton case that counsel cited. That was affecting the mode or use. There's also a few other sports bar cases, specifically also Winn-Dixie versus I think it was a Dollar Tree or Dollar General store. That was basically saying it's the covenant that's a restrictive covenant that runs with the land because you don't want competing chain retailers in the same shopping center. You don't want 2 sports bars right next to each other, 2 photo development companies right next to each other. So those were things that could affect the use and enjoyment of the land or the mode that the land was used. As for the practical effect of how these deeds come to be, the history of these deeds, and I'm sure your honors have probably all purchased houses, you get a stack of documents, you get a ton of closing papers, and the deed is given to you afterwards, executed by one party. It's not reviewed, it's not negotiated. here's your deed, here's your house. If you don't want this deed, you don't get your house, your earnest money, your deposit, the time that you spent. Homeowners are not really in a position to, at that point, seeing the deed, say, hey, wait, we have to talk about this arbitration provision, how that's going to affect the resale of my property to a subsequent purchaser if there's building code defects in the product that you installed. It's just not something that can happen. So in that case, it is kind of an adhesion type issue where one party is just executing it, putting whatever they want in the deed, recording it, and now saying, homeowners, your subsequent purchasers, and everybody in perpetuity, you're all bound by these restrictions, and we're going to make them run with the land. We're going to put in the deed. We're going to put in the purchase and sale agreement. We're going to put in your limited warranty, and we're going to put it everywhere we can put it because we just would prefer that. So that is the net effect of agreeing with the argument that these arbitration provisions can run with the land and will be binding on all successors assigned in perpetuity.
Gentlemen, well argued. Thank you. It's a very interesting issue.